The next matter to come before the court for argument this morning is in re L.S.J. Each side will have 15 minutes in which to present its arguments. The appellant may reserve up to 5 minutes for rebuttal. If you wish to do so when you take the podium, just let me know, and I'll do the best I can to monitor the time for you. You can also see it on the television over there above Kit's head. The arguments are being visually and audibly recorded to be posted online, so please keep your voices up and remain behind the podium. Normally what I would say next I don't think applies in this case, so I'll just say we have read your briefs and we are ready to proceed when you are.
May it please the court, Lawrence Reinhold on behalf of Lori Johnson as guardian and attorney, and I would request 5 minutes of rebuttal time. The issue before this court is whether or not the Summit County Common Pleas Court Probate Division has jurisdiction over an administrative appeal involving the nursing home placement of one of its wards based upon a PASAR. A PASAR is a pre-admission screen and resident review that in this case, the two of them that were conducted by nurses. It's my position that pursuant to Article 4, Section 4 of the Ohio Constitution, which provides that the Common Pleas Court and divisions thereof shall have original jurisdiction over all justiciable matters and such powers of review of proceedings of administrative officers and agencies as may be provided by law.
Counsel, before you get to
Yes.
how you frame that issue, I think it probably came as no surprise from the orders that came back and forth that we would be discussing also perhaps whether or not this is a final appealable order at this point. And I know that your argument is that it is. Can you tell me why?
Well, I think that the reason that it is that the probate court not only has jurisdiction, but it has exclusive jurisdiction over the matter. So if you transfer it to another court, you're transferring it to a court that doesn't have jurisdiction. The other problem that arises, obviously, is the court's specific order placing Lori Johnson at Wyatt Woods. So if you send it to the general division of the Common Pleas Court, the court couldn't overrule, it doesn't have the power to overrule the bankruptcy court placement order. So, but I think that the real problem, and it's related, intertwined with the other issue, is it's not only jurisdiction, not only constitutional jurisdiction and statutory jurisdiction, but exclusive jurisdiction. And that's why it can't go to another court, and that's why I think it's a final appealable order.
Is she being deprived of some remedy by having the Common Pleas Court General Division decide this case?
Is she being deprived? Yes. Well, I guess in this appeal, if it stays in the probate court would have the ability to affirm the PASAR.
But couldn't the Common Pleas Court do the same?
No. Well, it could affirm the PASAR, but it can't get past the probate court's order. It can't change that order. It doesn't have the authority to overrule the probate court. Now,
Well, the
this court,
argument from the other side is that the probate court's order was temporary.
well, the order said, you mean the placement order? The
Yes.
original? As I recall, it said that until further order of the court. So I guess that it may be temporary, but it has to be, because if you look at what the court has to do, it has to keep track of the ward, keep track of the placement, and make sure that the ward is in the least restrictive alternative. I mean, that's kind of where it parallels, allegedly, the purpose of the PASAR, because that's to determine whether the placement in the nursing home is appropriate, but the probate court has that continuing duty to do that as well. And it goes both ways, that if someone's in a placement and the less restrictive alternative is appropriate, then the person has to be moved, and the probate court issues an order to move them. If, going the other way, the person is in a group home, like in this case, and they want to go to a nursing home, the probate court has to approve, there has to be a hearing, and the probate court has to approve a more restrictive placement. But I think that because of the nature of the in-rem jurisdiction over Lori Johnson, that only the probate court can make those decisions, which raises other questions about the nature of the statutory scheme involving the PASAR, but basically.
Could the probate court issue a subsequent order that based upon the statutory findings, you know, and basically undo its last order?
Yes, I think the probate court always has, you know, the power to do that, and any court has the power to always revisit its orders. But I think also, in reality, it has a duty to do so, because if it finds that a less restrictive alternative is appropriate for the ward, then I think it has a duty, when you look at the statutorily what it's supposed to do, that it has a duty to move the person out of the more restrictive environment.
Well, if the common pleas court were to hear the appeal, its review is very limited. Why couldn't it just make that review and then the probate court act accordingly?
Well, the problem is that you've got the order from the court that placed her there. And regardless of the PASAR, you know, whatever the nurse found, because that's basically what it is, it's the nurse's finding is the basis of the PASAR, that can't be the basis for vacating the court's order. So on the one hand, you have the common pleas court saying the PASAR is correct, the less restrictive alternative is appropriate, which it can't do because it's reviewing a matter that's under the exclusive jurisdiction of the probate court. But if it issues that, then quite honestly, we're back up here because you have the probate court's order that she stays, and then you have a common pleas order that says that she should be discharged to a nursing home or at least a less restrictive alternative. And I think that's the problem in this particular case. But I'm not even sure you have to get a specific order from the court because she's under the exclusive jurisdiction of the probate court now. So only the probate court can decide. I don't even think, quite honestly, and it's beyond what we're arguing about now, but I don't think honestly that scheme of the administrative code for the PASAR and the review by the mental health department and all that stuff passes the test of a separation of powers, because it's not, what they've done is set up a parallel scheme where an agency can overrule the probate court. If the probate court has the hearing and decides it's in her own best interest, it's safer for her, and she should stay in the institution, then you've got the state saying no. So you've got the state agency overruling a common pleas, the division of the common pleas court.
Well, wasn't there a pretty significant amount of time that passed between the probate court's order and the state?
1 year, give or take.
There can be changes, yes.
Well, but there weren't in reality. I mean, that's in part of the, they did two PASARs. They did the first one where they didn't notify the guardian, so I wasn't there. So then when we appealed that, they ordered a second one. During the second one, Lori refused to cooperate. She refused to answer questions. She refused to say anything. But I had an opportunity to talk to the nurse, as did the social worker and the nurse in the ward. But because Lori wouldn't answer her questions, they adopted the original report. I mean, it seems to me that if there's a change in circumstance, that it's the probate court that decides the issue, not an agency of the state of Ohio. And I think there's the issue, you know, like I said, of the purpose of the PASAR is to decide whether a person is appropriately admitted to the nursing home. And I think if you look at the responsibilities of the probate court, first of all, that it has in rem jurisdiction over Lori, which is different in the sense that it also has statutorily the custody and maintenance. It's responsible for her custody and maintenance. It's responsible for her protection, and it's responsible to control her as a person. It also is responsible to authorize or approve medical care, health care, and other professional care. And if you look at what is being provided within the context of the nursing home, those are exactly the things that the probate court is statutorily required to examine and ensure in terms of Lori's well-being. And I think that, excuse me, if you look at the, the appeal process, says it just goes to the common pleas court. It doesn't specify the general division. And if you look at the constitutional provision, the probate court has jurisdiction. So then the question is whether the legal requirements of the duties of the probate court, the control, the placement, the protection, the medical care, and other care for Lori, whether that jurisdiction is sufficient to give it jurisdiction on the appeal. And I think that if you look at what the Supreme Court has held, that is if they have jurisdiction, which I think they do because it's interim jurisdiction over Lori, that it's plenary jurisdiction and it's exclusive. And I think that's why this differs from, you know, other cases that may come, because she is a ward of the court, and as a ward of the court is responsible for her, not some state agency. I think that, you know, the placement of a ward who's under the jurisdiction of the court is always a question for the courts and not a state agency.
You're right, it's your 5 minutes. You can go on if you wish.
No, I'll reserve it.
Good morning, Mayor, please support Becky Thomas on behalf of the Ohio Department of Job and Family Services.
Can you also address the final appealable order issue that Judge Callahan
Yes,
brought up?
thank you. The order transferring the case from one division to another division of the Common Pleas Court is not a final appealable order. It doesn't meet any of the criteria listed in 2505.02B, and it doesn't meet any of those. Did I say that right? 2505.02B, I'll say it again just to make sure. It doesn't meet one of those categories. Then an interlocutory order cannot be appealed to a court of appeal.
And I'm scratching my head a little bit about that, because you just said the order transferring the case.
That's right, from the probate court to the general division.
But am I right in understanding there was actually an existing guardianship case
Sure.
that's
Sure.
still open?
Yes.
So I don't know how a case got transferred, because the case in its entirety didn't get transferred, is that correct?
The court seems to have it transferred it as if it had been filed there, which I took to mean take this notice of appeal and think of it as being filed in the Common Pleas Court. But at any rate, regardless of how you look at it, you can't find anything, I don't think, in 2505.02B that describes this order. It's merely a change in forum. There is no risk that the appellant won't get an effective remedy on appeal, and that is required. Even for B2, which is the only part of the statute that appellant argued does apply, that has two prongs. Even if you think the first one is met, and that's an order affecting a substantial right made in special proceeding, we don't think it meets that prong, but it definitely doesn't meet the second prong, because there's no hint that there won't be an effective remedy by way of appeal when it finally goes up, if it does, from the general division's final judgment. For those reasons, this court cannot hear this appeal at all. It's just not something that can be appealed now. It can be appealed later, but not now. If the court disagrees with us about that, then we move to the question of the probate court's jurisdiction over the appeal. I would like to say as a general proposition that most of the arguments you heard from my friend on the other side today are arguments you would make to the general division when you're there and it's hearing the appeal. You can't collaterally attack a probate court order, the probate court has exclusive jurisdiction. Whatever those arguments are, those arguments can all be made to the Common Pleas Court. That court has complete authority to decide whether the agency's order was in accordance with law, in addition to whether it was supported by reliable, probative, and substantial evidence. Well, in accordance with law is very broad. Does it meet constitutional provisions? Does it meet the statutory provisions? So all these arguments are not gone just because they can't be addressed now. They can be addressed by the general division. The probate court doesn't have jurisdiction over this appeal because
Your opponent he's citing Ohio Constitution Article 4, Section 4, which you quoted in your brief as well. And apparently it says the courts of common pleas and the divisions thereof shall have original jurisdiction in all judicial matters. What does "and divisions thereof" mean in your
any divisions of the Common Pleas Court that may be established have jurisdiction as provided by law, which the Ohio Supreme Court has consistently and repeatedly interpreted as meaning provided in a statute. No statute gives the probate court jurisdiction over these appeals. 2101.24 tells you what the probate court can do. Nothing in there even arguably gives the court jurisdiction over an administrative appeal. It's true that a probate court is the superior guardian of the ward and controls the actions of the guardian, and on all matters touching the guardianship itself go to the probate court. This matter does not touch the guardianship. It's also true that the court's orders issued under 211150, which are to place the ward, can be done only as far as it doesn't contradict a statute. It's right in that statute. The court can only do things that aren't otherwise prohibited by law, and the Supreme Court also said that in the Lombardo case, which we've cited. The powers of the guardian in the probate court are limited to that which is allowed by the revised code, or at least can't do anything that's inconsistent with the revised code. Well, the revised code contains 511940, which requires the assessment that was done in this case. These assessments are required by federal law, and we have to do them as a state in order to participate in the Medicaid program. Any Medicaid certified nursing home has to undergo these kinds of assessments because we do not warehouse people with serious mental illness in nursing homes. That's not what nursing homes are for. That's not what they're licensed to do. They do something else. So we have to place people with serious mental illness in the least restrictive setting, as my friend said, and that requires these assessments. To the extent that the probate court placement order purported to be anything other than temporary, it was void because due to what I said earlier about the court doesn't have the power to do things that are against the law, that are prohibited by law. The revised code requires that these assessments be done under certain circumstances, one of which was met in this case, which was a notification to the agency by the nursing home that there had been a significant change in condition. That's not in the record. It's in the first decision that my friend referenced, where they didn't have the guardian participate, so they sent it back, which shows that the appeal process of the agency is working fine because they redid it. They said that wasn't right. We redid it. In that first, which can be looked up online, there's a database of these decisions online that have been redacted for identifying information. You can see that the reason that the assessment was done, the original reason was the notification of a significant change in condition. And if the court would like to see further details about these reviews, you could look at the Administrative Code 5122-21-03, which lays out how the department has to do these provisions that was enacted under 5119.
Give me that number again.
5122-21-03. There's also a lot of overlap with that, plus some extra information in Ohio Administrative Code 5160-3-15.2. Those will show you what kinds of things are required for these assessments and all the protections that are afforded to people who are residing there, who undergo these reviews. They not only get to appeal the result of those reviews, but when the nursing home, if the nursing home is proceeding to discharge the person, there's a notification that goes along with that under Revised Code 3721.16, referenced in that rule, by the way, one of the rules I mentioned. And that is a whole process. And the discharge planning has to include relocating the person to an appropriate setting, not just anywhere, someplace that has accepted the person and can meet the person's health and safety needs. That's in 3721.16. So it's not that the person is going to be sent on their way without have a nice day. There's a long process that goes on that places the person in an appropriate setting. And that is required for how to participate in the Medicaid program. This nursing home is a Medicaid certified facility. It has no choice but to participate in these reviews. And the probate court's order could not have done what it purported to have done if that's what it was. It looks to me like it's a temporary order that placed someone who is in crisis into a nursing home, and then the crisis was over and the change of condition happened, and the nursing home said to the agency, we need you to do a review to see if she still needs nursing home services, and she was determined not to.
Would that review be done whether or not the nursing home requested that it be done?
I don't think so. There may be some circumstance where it can be done without the request, but the general idea is that the nursing home, because if the person is there, they're presumed to have needed the services for some reason, that's how they got in. And the nursing home is supposed to say, hey, there's been a change in condition. We need to reassess and make sure that this person should still be in a nursing home and not someplace else. But again, a lot of these underlying issues can be argued to the general division but to the extent that they would touch on the asserted jurisdiction of the probate court, they don't, because the probate court didn't have jurisdiction to place anybody in a Medicaid certified nursing home permanently or even indefinitely. And the probate court, I'd like to remind the court, the probate court agreed with us that it didn't have jurisdiction over this appeal. So it transferred the case over. And back to my original point, that was not a final appealable order. And if this is wrong, this can be addressed later on appeal. That's what the statute indicates. And that the General Assembly decides what the courts can hear and what the courts of appeals can hear. It chose not to allow these kinds of interlocutory orders to be heard by a court of appeal.
Trying to think back to my days on the common police court bench. Are the administrative appeals, aren't they filed under a separate case number?
Yes,
So they are separate
they're
cases?
independent appeals, that's correct. And we've addressed that in our brief. I realized belatedly that perhaps because I did not take a cross appeal, I can't say too much about what the court ought to tell the probate court if it reverses, but the court can consider any jurisdictional considerations that it wants to sua sponte and decide whether it has jurisdiction over this appeal, and if it reverses, if it needs to give any instructions to the lower court. I've never heard of an appeal being filed inside of another case. It's always its own case as far as I've ever seen. And the language that we cite to in the statute, the statutes that govern 5101.35 and 119.12, they use words that show you that they're independent cases, and never mind all the other reasons we gave, which is the standards of review differ, the docket priority differs, the fact that one is adversarial and one is non-adversarial matters. All kinds of things are different between the cases, and they can't really be litigated together anyway. But there's no provision that I've ever seen that would allow an appeal to be filed as part of another case.
May not be in your area of expertise with the state, but let's say the Department of Taxation administratively determines taxes are due from a state. They have their hearing, and isn't that appealable to the probate court? If you know.
If they don't, I don't know.
Maybe that wasn't a fair question.
Whether from an estate,
Yeah, whether or not the estate
whether there's,
owes money to the state of Ohio Department of Taxation. I'm assuming that's the same
Well,
process. You have an administrative hearing, it's determined that the state owes money.
tax
think
cases
those
are
are-
extra special, and they might not even go to the common police court at all. I think they might go to the.
I didn't know if there was a statute
I'd be surprised.
providing. Yeah, I'm going to withdraw your question because
I
I
should
don't want to
withdraw
say
my
that.
answer to that, no, it's not.
Yeah, I'm looking at the last sentence of 512221, discharging involuntary patients, where it says after finding pursuant to 512252 revised code, a person, a mentally ill person subject to court order, it does say the chief clinical officer may grant a discharge without the consent or authorization of any court. So if the person didn't want to be discharged at that point, what would they do at that point? They would appeal the discharge completely, right?
Anytime a nursing home discharges someone, they can appeal that under 3721.16.
And where do they do that?
They appeal in the Department of Health, and I think there are 2 levels of appeal there, and then it can go to common police court, just like this kind of appeal can, and up through the courts. I'm not sure which rule you were mentioning, was it the same one?
It's revised code 512221, discharging involuntary patients, and in this case, then this person's involuntary. There's a temporary order on placing her at this location, but the way I'm reading this, it looks like that the chief clinical officer could discharge that person without the consent or the authorization of any court.
Okay, well then and I'm sorry, I didn't see that, that's in the administrative code,
That's a revised code.
Revised code.
2221.
okay. Then that would be another indication that the court's order could not prevent this assessment and discharge from happening. If the discharge is allowed to happen regardless of a court order or consent of a court. But regardless, there's an appeal process there.
Right.
And again, because for other reasons at least, that court order could not be valid as a permanent order. It's outside the probate court's jurisdiction to order someone to skip these assessments that are required by state and federal law. Then it wouldn't have it wouldn't have any, there wouldn't be a conflict between that order and this process. But if there were, that could be argued to the general division and come up here and appeal properly later when there's a final appeal warrant. If there are no further questions, we ask
I have no
you to affirm.
Thank you.
May it please the court, just a couple of points, that in terms of the statutes that control the power, that have been acted either under the administrative code or the revised code, just because it's a statute doesn't mean that it's constitutional. It seems to me that if you're talking about the power of the probate court, that's guaranteed under the Constitution, and the court, the legislature can't deprive it of the jurisdiction that it already has. And I think that certainly it can't give the jurisdiction or the power to an administrative agency to overrule a division of the common pleas court. And in terms of why the PASAR was ordered, it was because she had gone to the hospital and come back. So it was a change, that was the change in circumstances, that she had been returned. So that's why they requested it. And in terms of, the probate court's order about a Medicaid appeal or termination of Medicaid, I am unaware of any indication in the PASARs or the administrative appeal or the state hearing appeal or any of that stuff where termination of her Medicaid was even an issue. It was all whether the placement at in Wyatt Woods was the appropriate placement. And as I said before, I don't think I have an effective remedy by raising these issues in the common pleas court, because the argument is that the common pleas court doesn't have jurisdiction. So if it doesn't have jurisdiction, then you can't raise the arguments. And anyway, if there are no questions or...
All right.
All right,
Thank you both for your arguments. We'll take the matter under advisement, issue our written decision in due